The 2021 New York Statutory Power of Attorney. In 2021, New York overhauled its power of attorney law. The state simplified the statutory form, allowed minor deviations from the exact wording, and added safeguards against abuse. Anyone who may need another person to handle finances should understand these updates because institutions often reject documents that do not meet statutory standards. The revised statutory form applies to powers of attorney signed on or after June 13, 2021. Older documents remain valid but may be harder to enforce, so revising them can prevent confusion or delay. A central New York estate planning lawyer can review your existing documents and recommend updates. A power of attorney lets a principal appoint an agent to handle personal or financial matters. In New York, these documents can be statutory or non-statutory. Statutory forms follow the outline in General Obligations Law Section 5-1513 and offer stronger enforcement when third parties resist an agent's authority. Non-statutory forms may still be valid but can be harder to enforce. Because accidents or illness can strike without warning, every adult should have a durable power of attorney to avoid guardianship proceedings. The 2021 law introduces several substantive changes. The new form only needs to substantially conform to the statutory text. Minor spelling errors, different fonts or formatting, and optional sections marked intentionally omitted do not invalidate it. Drafters should still use the statutory form and place changes in the modifications section. Because the statutory gifts rider was repealed, any gifting authority must be included in that section. Agents now have broader power to manage healthcare finances, including obtaining protected health information and paying medical bills. To prevent abuse, the principal's signature must be notarized and witnessed by 2 disinterested witnesses, and a third party may sign for the principal only under strict conditions. Even with these safeguards, the agent's authority is limited to what the document authorizes. A power of attorney is valid if it meets the execution requirements, but an agent must stay within the powers granted. The article gives an example where a daughter, acting under her father's power of attorney, wrote a large check that the document did not authorize and became liable for the amount. To encourage acceptance, the new law shields third parties who rely on a power of attorney in good faith. Banks and other institutions may accept a document they believe was properly executed or rely on an agent's certification or an opinion of counsel. They must follow timelines when accepting or rejecting a document, and agents can seek court enforcement if a refusal is unreasonable. These provisions give agents recourse while providing clear guidelines for businesses. The 2021 updates simplify drafting, expand an agent's authority over healthcare finances, and encourage banks and other institutions to honor valid documents. They also impose stricter execution requirements and outline procedures for good faith acceptance to protect principals. For peace of mind, consult an attorney experienced in estate planning. Davies Law Firm at 210 East Fayette Street, Syracuse, New York, 13202 serves Central New York and prepares powers of attorney, wills and trusts. Their phone number is 315-472-6511. An experienced lawyer can tailor a power of attorney that aligns with the new law and protects your interests.